Good morning. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and welcome to our Advisors Forum today, the discussion regarding the uses and purposes of irrevocable trusts in 2022, presented by Elville and Associates Managing Principal and Lead Attorney, Stephen Elville. So how this will work today, if you're new to our webinars, if you are, welcome. We're glad you're here. And if you're returning, welcome back. So you as the attendee are in listen-only mode. However, if you have questions, please pose them throughout the presentation, and I, as the moderator, will work with Steve to pause periodically to answer them, as well as leave time at the end for Q&A. You also received the presentation yesterday by email from me for your convenience to take notes on it if you wish. If you did not receive the presentation for some reason, it is available in the handout section of your dashboard to download at this time. Everyone will also receive a post-webinar feedback email right after the presentation, and we ask that you please take just a couple minutes to fill out this simple survey to offer us your feedback about the presentation. For certified financial planners, CPAs, and other professionals on today's webinar, you may receive 1.5 continuing education hours for attending. If I don't have it already, please email me your board ID, and for CFPs, the last four digits of your social security number as soon as possible. I'll also be sending out certificates for CPAs and others soon after today's presentation. As a reminder, virtually all of our webinars in our Elville webinar series are available for CE hours, not just the Advisors Forum. So we have many advisors on today's webinar, and we also have some clients who also expressed interest in attending. So thank you again for being here. So most everyone knows Steve and the firm, but for those who don't, I'd like to share just a little bit about the firm and Steve. So Elville and Associates, we were founded in 2010 in Columbia by Managing Principal and Lead Attorney Stephen Elville. We have a number of different practice areas, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, tax planning and asset protection. And we have 7 attorneys, 12 staff members, and 5 locations. And our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. We do offer a lot of education here at the firm, and we do that in a number of ways. We do that through our planning processes with our clients. We also offer over 100 educational webinars and workshops in the communities we serve each year, and also by way of our accredited client care program. We're one of only 2 firms in Maryland to have an accredited CCP, as we call it, accredited by the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion in mind with every client, every day. Also, a little bit about Steve. Steve's work as an attorney for the past 20+ years has been centered in elder law, special needs planning, and estate planning with an emphasis in the areas of tax planning and asset protection. He's a member of many different national organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. He works to bring peace of mind to clients by creating solutions to their needs through counseling, education, and the use of leading-edge legal technical knowledge. A very seasoned speaker presenting at many webinars, workshops for businesses and their employees, conferences, and continuing education events each year. Also recently named to the Maryland Super Lawyers list for a 7th time for 2022, so congratulations to Steve. Also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, our firm's charitable organization he founded in 2014, and I am privileged to be the executive director of. So if you'd like to learn more about the Elville Center, please contact me, and I'll be happy to share a little bit of information about it, the Elville Center, and what we're doing to make a musical difference in the lives of children each day. So with all that being said, I'm going to go ahead and turn the presentation over to Steve. Steve, I'm going to make you the presenter here in just a second.
Thank you, Jeff.
You should see that link pop up.
All right, very good. I'm taking control of the screen here, and I'm going to share my presentation with you here from my desktop. And bear with me for a second as I do that. And we'll get started here shortly. Jeff, I'm just trying to make that happen, and let's see. I'm going to just.
There it is.
All right, Jeff, can you see that?
I can see that, yes.
Thank you very much. And I'm going to start my slideshow. All right, thank you very much, Jeff. And good morning, everyone. And happy Friday to all of you. And it's so good to be back together with you again for the Advisor Forum in 2022. I thank you for sharing your time and energy with us this morning when you could be doing so many other things. And I hope you're getting ready for the snow and that event for some of us. And I hope you're safe and well in 2022, you and your loved ones and family and colleagues. And I want to thank you and also thank Jeff Stauffer, my good friend and colleague who has been working with me for so many years. And without Jeff, I could not put on these presentations. So I thank Jeff. And I just wanted to remind you, Jeff is an expert moderator and he's going to take questions. Jeff, because of the nature of this presentation and we have so much to cover, I probably won't stop throughout the presentation like I normally do. But I want you to please stop me if you have a series of questions you're receiving from anyone. So Jeff knows that if you have questions, he will share those questions with me either during the presentation or at the end. So hopefully we will have time to do that. Now, I thought as I was putting this presentation together, you know, gosh, there's been so many things that were talked about in 2021 that did not happen. So many legislative and tax changes that were proposed but did not happen, but still could happen. But thankfully, we still have a lot of the same tools in the toolbox for 2022. So I wanted to share that with you. And I also wanted to make this, I would say, a mini master class, so to speak, about just understanding irrevocable trust. Some people, or many people, I should say, have the same questions over and over. Many clients. What is an irrevocable trust? So I thought it would be a great topic. So I'm going to educate you this morning to the best of my ability. I want you to use this presentation as a tool, as we always want you to do, and actually mark it up if you have a printed copy or on your computer, make notes. Use this as a tool. Use it to learn how to communicate with clients. If you're a client or potential client on this webinar, use it as a tool to educate yourself and your loved ones. So we want to be intentionally redundant in this presentation so that we can make some key points and make sure we drive home information that substantively you will walk away with some points here today. But we also want to give you a path forward as an advisor so that you can work collaboratively with us at Elville and Associates and with CPAs and others as part of an advisory team. So we want to not only educate, we want to collaborate. So with that said, we have a lot to cover and I'm going to go through a lot of material. Please stay with me and we're going to just get started now. So here's a brief overview of today's presentation. We're going to look at the estate planning outlook for 2022 and basically take a look at this here at the beginning of the year, even though we're here at the end of the month. Why clients should care about irrevocable trusts in 2022. So we're going to talk about that. We're going to ask and answer a fundamental question about the differences between a revocable trust and an irrevocable trust. So we're going to drill down into the real fundamentals. And for those of you who are very seasoned and you understand this already, I hope you'll bear with me as we try to speak to those who are possibly still have some misunderstandings about these basic things. What are the most common and available irrevocable trusts in 2022? What are the uses and objectives of these trusts after we identify them? And we're going to go through about 20 different types of trusts. And I want you to know from the outset, this list is not a comprehensive list. There are certainly other trusts above and beyond these 20 that I've chosen to talk about this morning, but we're going to talk about their various objectives and uses. We're going to have a very brief discussion of taxation at the end of the discussion. So hopefully we'll have time to get to these slides at the end. Taxation of irrevocable trusts, a very brief overview. We're going to talk about flexibility and the need for flexibility. We're going to talk about new trusts and the kind of flexibility that can be in those trusts versus older trusts that may not have any flexibility. So how do we deal with that? And how to discuss and describe irrevocable trusts with clients. How do we do that in an effective way? And then we're going to talk about client goals and the purposes that certain clients have in their planning. And in my view, this is the key. This is the key to harnessing the power of irrevocable trusts. And of course, part of that is we believe here at Elville, we believe in educating clients. So we want to utilize client education to help them make decisions and accomplish their goals. All right, so let's get started. Well, this won't be news to many of you. There is legislative stasis, meaning that there was a lot discussed starting at the beginning of last year or the spring of last year. Senator Sanders and many people on the left and Senator Van Hollen, Janet Yellen, many people, including the president, had a legislative agenda that was very bold, and it had to do with lots of things. The reduction in the estate tax exemptions, it had to do with taking away the step up in basis and many things that you're familiar with. And most of those things, if not all of them, never happened. So we had a lot of buildup. The Building Back plan from President Biden has actually stalled, as many of you are aware, and only a very small part of that and the infrastructure bill was passed. We still have federal and state estate tax exemptions that are unbelievable. They're huge. 12,060,000 on the federal level, 5 million on the state level in Maryland. We still have that. This is a wonderful thing. We have a cost basis adjustment that survived. So the government did not take away the step up in basis. Maximum tax rates remain unchanged largely. The use of grantor trusts, which is one of the things we're going to be talking about today, is basically unchanged. And estate and gift tax rates remain unchanged. So we have continued opportunities for basic planning and advanced planning. So in a sense, there's never been a better time to do planning. I mean, it's just incredible what clients can do in the world today with all of the state laws of multi-jurisdictional practice. And I know many of you have licenses all over the United States. You have clients in different states. And I think we've had a reprieve from the inevitable changes, right? So all of these changes, all of the things that your top advisors tell you and teach you in CLE classes, and all of the things that we learn in our professional development, these things never happened, but they still could happen. But we have a reprieve from that, and we have to be mindful as we do planning that things could change. So we want to build in flexibility. The time pressure that many of us on the legal side felt is on hold. We had a lot of time pressure building up to the end of the year. Many of you who are CPAs had time pressure, but we still have these unprecedented exemption amounts. We have grantor trusts. We have life insurance as a powerful tool. And I think this reprieve has given many clients the time to think through tax issues, to think through issues that were being rushed at the last quarter, at least, of 2021. Now, as we get into the discussion, I want to make sure I keep moving. What is the difference between a revocable and an irrevocable trust? Well, for those of you who already know this, please just take a pause, but I'm going to talk to the people who do not understand this concept. So a revocable trust is merely an alternative for a will. If I'm looking at a will as part of basic estate planning, I could have an alternative to a will or a substitute for a will, and that's a revocable trust. It avoids probate if it's properly funded. It has no asset protection provisions because it's just a reflection of the person. It's the reflection of the client. It has no income tax savings. So whether I have a will or a revocable trust, I have no income tax savings. It can be changed or terminated by the grantor of the trust. And it is a classic example of a grantor trust. A grantor trust is a trust, as we're going to talk about further today, that pays, where the grantor, I should say, pays the income tax and not the trust itself. So the revocable trust is a grantor trust, and as such, it is ignored by Uncle Sam. Now, an irrevocable trust. What is a general definition of an irrevocable trust? Well, there could be various ways of describing it. I like to describe an irrevocable trust as basically a trust that is created for a special purpose. So an irrevocable trust avoids probate if it's properly funded and aligned, just like a revocable trust would avoid probate if it were funded and aligned. It can provide asset protection to the beneficiaries, and most of the time that is a goal of an irrevocable trust. We're going to look at examples. It can be created during life or at death. So there are irrevocable trusts created at death, irrevocable trusts created during life. It can be a grantor trust, a trust where the grantor pays the income tax, just like a revocable trust, or it can be a non-grantor trust where the trust pays its own income tax. And it can remove assets from the grantor's taxable estate, and it can provide income tax advantages. And again, many people on the left in Congress, and probably not so many people on the right, but many people on the left wanted to change these things. They wanted to change the tax advantages, and they wanted to change the ability of someone to stretch out a trust forever with the advantages of generation skipping tax advantages and so forth that we currently enjoy. So it can remove assets from the taxable estate and provide income tax advantages so long as we still have the same legislative scheme that we have now. Now, I'm just going to give you some examples of the most common trusts, okay? Irrevocable spendthrift trusts at death. Remember, we can create irrevocable trusts at our death. Why am I calling it a spendthrift trust? Because in my view, this trust would have a spendthrift clause that provides asset protection. So we first of all need to understand that when we die, we can create irrevocable trusts at our deaths. We can create irrevocable trusts that are basically what I would call gifting trusts, lifetime gifting trusts. A client wants to gift assets to their children or grandchildren. Well, that trust would be an irrevocable trust during their life. A life insurance trust is a classic example of an irrevocable trust. We'll talk about that further. A spousal lifetime access trust, or what many of you would refer to as a SLAT. That is a very common trust today that's especially popular in the last 2 years. A charitable trust is going to be irrevocable. A Medicaid or Veterans Trust in the elder law world, that's going to be irrevocable. A marital trust or a bypass trust, and many times over the years, the bypass trust has had several names. A family trust, a credit shelter trust, and so forth. So these are terms of art for revocable trust planning most of the time, but we're going to see there are some variations of this, but these are examples of irrevocable trust. Grantor retained annuity trust. This is called a GRAT. This still has use because the 2021 laws never happened. That would have largely taken away the benefit of a GRAT. Special needs trusts can be revocable or irrevocable, but they're always irrevocable at the death of the grantor. A minor's trust or an education trust, these are similar trusts. A dynasty trust, this is a term of art. This is a trust that is a bloodline trust. Sometimes it's called a generation skipping trust. This is a trust that's designed to stay in the family bloodline generally, and it's to last for generations. And in Maryland, a trust can last forever. So a dynasty trust is a trust that can last forever in a multi-generational sense. Domestic asset protection trust, we're going to talk about that today. There are 19 different domestic asset protection states, basically states where someone can self-settle a trust and have asset protection. You cannot do that in Maryland, but a domestic asset protection trust is a trust that can be established in a state like Delaware or other states like Nevada or Alaska, where you can establish a domestic asset protection trust. A special power of appointment trust is an asset protection trust that is designed where, we'll talk about this just a little bit today, where the grantor is not the trustee, and the grantor does not really control the trust. It's controlled by others. So this is not something that is for the faint of heart, but it is a very powerful asset protection tool where the grantor can receive distributions, but they don't have control over the trust. and that's a powerful tool for the right person. Community property trusts, this is another example. This is a trust where we can get the treatment of community property for income tax purposes, which are tremendous, even if we live in a non-community property state like Maryland. Qualified domestic trust, this is where we have a non-citizen spouse. We're going to talk about that. Qualified personal residence trust, this is an estate discounting tool where we can create a trust for a residence or a second residence. A crummy trust, we're going to talk about that. What is a crummy power? What is a crummy trust? Quiet trust, a trust where the beneficiary does not really know information about the trust. And a standalone retirement plan trust. So I just wanted to give you a flavor of some of the things that we're going to talk about today. So let's get right into the 20 or so different trusts we're going to talk about today. Hang on as we get ready to roll here into these trusts. So the first one we're going to talk about is what we basically talked about right away, which was the irrevocable spendthrift trust at death. Remember that under a will or a revocable trust or an irrevocable trust, we can create these irrevocable trusts for others. So in a marital context, we are talking about Q-tip trusts or what is called marital Q-tip trusts. These are control mechanisms for the surviving spouse. Those are irrevocable and they provide asset protection. A bypass trust, we talked about the various terms of art. This is another thing that's created under a will or trust. A further trust for the control, protection, or management of a child's share or a grandchild's share or niece or nephew. These are the trusts that can be left at death, okay, or they can be created during life, okay? But this particular slide, we're talking about what happens at death. And these trusts are basically non-grantor trusts. These are trusts that are created at death. They are not grantor trusts where the grantor pays the income tax. They are non-grantor trusts and they pay their own income tax. So many of you are familiar with these types of trusts. These are basic protective trusts for a surviving spouse or others at the time of death. Now, lifetime gifting trusts. So now I'm switching from what happens at death with a trust to lifetime. So we can create trusts for spouses, grandchildren, children, or others during life. We talked about this a little bit, and I'm going to be intentionally redundant. But one of the things we didn't talk about so far is that there is a possibility of creating a lifetime Q-tip trust. So a lifetime Q-tip trust is a lifetime trust for a spouse. And a good example of this is where one of the spouses has a lot of money in their own name, a lot of assets, and the other spouse does not. And during lifetime, the wealthy spouse can create a trust for the other spouse during life, and the asset protection in that trust is really, really strong. So a lifetime Q-tip trust can be created between spouses, and this is a powerful tool. And Maryland's asset protection, I should say, for lifetime Q-tip trust is very strong. So that's a tool that's probably underutilized. Instead of having to wait till the time of death to create a marital Q-tip trust, that can be created during life if it's the right tool. A grandchild's trust can be created during life. An education trust can be created during life. A charitable trust, obviously, can be created during life, like a charitable remainder trust or a charitable lead trust. A dynastical trust, a dynasty trust, that's actually a trust that is irrevocable and will last forever until the funds are exhausted. That can be created during life. And these trusts generally can be grantor or non-grantor trusts. Now, this is not true for all of these, but generally speaking, what I want you to think about is the IRS has what they call the grantor trust rules. In the IRS code, section 671 through 678, okay? And estate planners use these rules to manipulate the goals of the client and to get from point A to point B. So in many trusts, we can decide, do we want this to be a grantor or a non-grantor trust? But just want you to know that that is a tool in the toolbox. Now, life insurance trusts, I think we're on our third trust here. It removes the value of life insurance from the estate of the grantor, not just the estate of the grantor, but out of the taxable estate forever. The grantor and the surviving spouse, and in future generations, the life insurance value can be moved out of the grantor's taxable estate. So many of you and most of you on this webinar know this. So you are very, very good and you're experts at this. We have first to die life insurance trusts, or ILITs. We have second to die ILITs, where the second to die of the spouses, that's when the funds come into the ILIT. It provides control for the grantor insured spouse. It provides asset protection for the beneficiaries. It also can be used to leverage gifting, as the grantor gifts assets into the life insurance trust to be able to not only pay the premiums for the life insurance, which will be paid by the trustee, but also to, let's say, get assets further out of the estate of the grantor. So it can be used just to pay premiums, or it can be used to get assets out of the estate. And as many of you know, this is a tool. The life insurance trust is a tool to deal with the taxable estate. Many of you are managing unprecedented amounts of growth of assets. And so congratulations on that. But our clients are becoming wealthier and wealthier. And even those wealthy spouses and clients that are even beyond 2 exemption amounts are still going to have taxable estates. And remember that even if we're planning for these exemptions to remain in effect, which by all indications they will remain in effect at least for a while, up until 2026, remember that eventually we could expect the exemptions to come down. So not only do you have tremendous growth of the assets under management and assets in clients' estates, and not only do we have the Secure Act, which is accelerating the taxation of retirement plan assets for beneficiaries, we have the prospect that the exemption amounts are going to come down. So the use of life insurance and the use of life insurance trusts, in my opinion, cannot be overemphasized. So this is a tremendous tool. And in 2021, there was talk that the life insurance trust advantages were going to be taken away. So I don't know if you recall this or not, but this was a very scary thing, that Congress was going to limit the use of grantor trusts. And one of the most common grantor trusts, as you see in the bottom bullet point here, the life insurance trust is usually a grantor trust, that Congress was going to take away this advantage of the grantor trust, including life insurance trusts. So thankfully that has not happened. And also thankfully, although I don't have any kind of inside information on this, colleagues across the country have kind of told me that they believe that the life insurance lobby is very strong and that they are lobbying strongly against Congress taking away the advantages of a life insurance trust. So hopefully this is a tool that will remain with us for quite some time. The Spousal Lifetime Access Trust. So this is a popular tool for spousal exemption planning. So what do I mean by that? Well, we know that we're living in an unprecedented time of tremendously high estate tax exemptions. Many of you on this webinar have had clients during 2020 or 2021 transfer large amounts to an irrevocable trust so that they make a gift for estate tax purposes and gift tax purposes of getting that large exemption amount, or at least a large amount of their exemption out of, in other words, they're using their exemption and getting that money gifted. So in other words, they're using their exemption amounts before these, quote, temporary exemptions go away. And so many of you have seen clients do that. We have certainly done a lot of that here at Elville, and we've used counsel and other asset protection jurisdictions like Delaware and Nevada to do these types of plans. So there is a loss of the step up in basis. So when the client is making this large gift, and an example would be, I'm gifting $11 million to a spousal lifetime access trust. I'm gifting that. My spouse and my children are the beneficiaries, okay? But by me making this $11 million gift, I have used 11 million of my exemption. So when my exemption theoretically gets reduced someday down to 5 million or 6 million or whatever it is, Senator Sanders wanted it to be 3.5 million. But when it gets reduced, I will have already used my exemption and I will not lose my exemption amount. So that opportunity is still available. We have to be careful if a client is making a large gift, because we don't know what Congress is going to do. We don't know if the 2021 conversation is going to restart. So if someone makes a large gift like this in anticipation of the exemption amounts coming down in the future, we have to make sure that if Congress were to implement any kind of retroactive law, and remember, Congress can implement retroactive laws when it comes to taxation. If they were to retroactively implement a law that affected the gift tax, we have to have a mechanism in place where the gift could be undone or considered to not be a gift or be nullified. So in some jurisdictions, and this is one of the big bullet points here, it's bullet point number 5, I guess, where it says the grantor can be added back as a beneficiary. So in jurisdictions like Delaware, the grantor can make this gift, they can use their exemption amount, and then later they can be added back to the trust. If you didn't realize that this could be done, this is a powerful tool. It may or may not be advisable, but it can be done where the grantor can be added back as a class of beneficiaries and actually become a beneficiary of the assets that they gifted. So it's an amazing world we're living in, and that is possible. Both spouses can establish this. So the idea for a wealthy couple that has in excess of the exemption amount, so they have a large amount of assets exceeding $20 million, they each can establish these spousal access trusts. They each can make a gift and use the exemption amounts if it's the right thing to do. The mechanics are critical. We don't want to make those trusts, implement those trusts at the same time. We want to have some time and space between those trusts. We may even want to implement those trusts in different jurisdictions. And these trusts are grantor trusts for income tax purposes. Now, let's think about the loss of the step-up in basis. That's another reason why life insurance could be critical, to really have life insurance as a wealth transfer tool. So I just want to emphasize that from an estate planner's point of view, life insurance still is the Swiss Army knife of what we're dealing with. Charitable trusts. So there are many charitable trusts. This is just, like I said, a mini masterclass on irrevocable trusts in general. So I'm not going to spend a lot of time on the various types of charitable trusts, which you will see in many presentations. So we're just going to kind of focus here on the charitable remainder trust. It can be an annuity trust or a unit trust. It's very popular. It can be established for a period of time, 5, 10, 15, 20 years, or lifetime. The numbers have to be crunched to see if this makes sense for clients. We want a client that's really charitably inclined here, right? Although there are some strategic uses of a charitable remainder trust to deal with the Secure Act and so forth. What is this really used for? It's really for someone who is charitable minded, right? Because we're going to have lifetime beneficiaries. Husband and wife can establish a charitable remainder trust. They can contribute low basis assets to this charitable trust, sell those assets within the trust with no capital gain. They can receive an income, and then after their deaths, children can receive an income if that's appropriate. And then at the death of the lifetime beneficiaries, this goes to charity. So this is a powerful, powerful tool, and we just need to use it and to know that it's not that complicated. And when the grantor makes a lifetime gift, meaning a charitable gift, they also get a current income tax deduction. So this is a powerful tool, and it is a non-grantor trust for income tax purposes. Jeff, I'm going to stop just a second to take a drink. I said I wasn't going to stop, but I think we're making good time, and I want to see if there's any questions.
Thanks, Steve. Right now, no questions.
Very good. All right. Thank you for your attention, and we'll just keep rolling. Hopefully, this is going to be a valuable tool for you. Medicaid and Veterans Trusts. Okay, now these are creations of the elder law bar across the United States. I'm just going to say roughly these began to come into existence in our use of everyday elder law practices around 2005. So I'm just going to say that. They're popular. I used the term Swiss Army knife. Well, I'm going to use it again. In the world of elder law, the Medicaid trust, I would say, is the Swiss Army knife of Medicaid planning, because it is used as a control mechanism. Let's say that I transfer assets to an irrevocable Medicaid trust. What is the real purpose of this trust? Well, it should be, and this goes back to client goals. It should be to start the 5-year look period, the 60-month look period for Medicaid. So when I make that transfer to the trust, I start that 5 years, hypothetically, okay, and I don't lose the step up in basis. Now, recently I reviewed a Medicaid trust that was prepared by another law firm, and it was not properly drafted, and the person had passed away, and there was no step up in basis. So that Medicaid trust was a terrible thing. It was not drafted properly. But a properly drafted Medicaid trust or veterans trust is going to protect the step up in basis at death. That is one of the main objectives of the trust. So we're starting the 5-year period. We are divesting the client of assets. We are still ensuring the step up in basis at death because of the drafting of the trust. And that's because the grantor retains a little bit of power over those assets. They maintain the power to change trustees. They maintain the power to change beneficiaries at their death. That's called a special power of appointment at death. It's actually called a testamentary power of appointment over the assets. And the other advantages of the Medicaid trust is it allows the grantor to transfer assets to the trust, and those assets are protected from the claims of the beneficiary's creditors. So I have permission from a former client to tell this story, so I'll tell a very brief story. There was a trust that we came to review and to work with a client that had been transferred from another firm. And in that trust, the trustees, I don't believe, were properly structured. And when the two sons who were beneficiaries of the irrevocable trust, during lifetime of the grantors, one of the sons got divorced, and his divorcing spouse tried to get the trust. In other words, if you can imagine this, the grantors of the trust transferred their house into this trust. They're trying to protect it from Medicaid for both spouses and protect it for the family. Upon one of the beneficiaries' divorces, meaning the beneficiary son of the trust was divorced, his divorcing spouse tried to get half of the house being owned by the grantor parents. So that was thrown out of court because the Medicaid trust protects against the claims of the beneficiary's creditors and divorcing spouses. So the grantor of a Medicaid trust or a veterans trust can transfer assets to the trust. They don't give up the cost basis adjustment at death. They start the 60-month period for Medicaid. They don't expose, I should say, the assets to the claims of the creditors of the children. So this is generally a grantor trust for Medicaid purposes, and it is a grantor and non-grantor trust for veterans benefit purposes. A veteran who is eligible for the aid and attendance benefit can transfer assets to a veterans trust, still have all the advantages basically of the Medicaid trust, but there's some hybrid things that go on in this trust that we don't have time to talk about today. It's especially designed for the veteran, and it's designed to preserve their veterans benefits, which is basically a tax-free pension, but it also has some income tax advantages so that the veteran has the best of all worlds in that trust. So Medicaid and veterans trusts are irrevocable trusts. Now, we talked about the marital Q-tip trust. I'm going to keep going. This is a popular tool in spousal revocable trust planning. And as I mentioned, it also can be a powerful lifetime tool, meaning it can be a lifetime Q-tip trust that can be established. Now, it provides the surviving spouse with asset protection and marital protection, protection against a bad spouse, a new spouse, okay? It maintains the step up in basis at death. So at the first spouse to die's death, there is a step up in basis. Thank goodness Congress has not taken that away. And at the second spouse's death, meaning many years later after the surviving spouse, let's say they live anywhere from 1 year to 20 more years or more, at their passing, the assets of the marital trust will receive another step up in basis, another cost basis adjustment. It protects the surviving spouse from the claims of creditors. And of course, it gives the deceased spouse control, right? That the assets are going to flow down to the beneficiaries designated by the deceased spouse, okay? This can be done in a will-based plan. It can also be done in a revocable trust-based plan. But the marital trust itself is a non-grantor trust, meaning the trust will pay its own income tax, and it is an irrevocable trust at death. Now, for those of you on this call who see this all the time, you see estate planning documents with marital trusts and so forth, you should be aware that in will planning, if the person who is the testator of a will includes a marital trust, sometimes the marital trust is created in the documents, but the assets were never retitled properly. We're talking about a will now. The assets were never properly retitled, so the marital trust never gets funded. So if we're going to use wills, we have to be especially careful to use certain types of funding techniques to get the assets into the marital trust. In my opinion, if a couple were going to use marital trust, it's much better to use a revocable living trust that would create the marital trust, mainly because when couples transfer their assets into a revocable trust, they can maintain tenants by the entirety's protection in their residence that still have it in the trust, and any other non-retirement assets that they would title as tenants by the entireties, which I would highly recommend that the tenants by the entirety's property be then transferred into the trust, and they can still maintain the tenants by the entirety's spousal protection of those assets, which is a very basic level of asset protection inside the revocable trust. And now, because we're using the revocable trust, we don't have to separate the assets into tenants in common, if this makes sense, so that the will plan could work. So in a will plan, we have to separate assets. And for a couple, I don't think that makes sense because the couple is giving up their marital protection, the husband and wife or spousal wife or husband, tenants by the entirety's protection. So the marital trust is a powerful tool. The bypass trust is also a traditional tool that is used in revocable trust planning, basically. Now, revocable trusts obviously create irrevocable trust, and the bypass trust is created, for example, under a will or a revocable trust. So this is a spousal tool. It is for asset protection and marital protection. It's also in a lot of older plans as something that was part of a formula. So if you're looking at an old trust from the 1990s, it almost always, not always, but almost always has a formula that's going to create a bypass trust. So it maintains the step up in basis at death of the one spouse, the first spouse, but not at the death of the second spouse. But it does protect the surviving spouse from creditors. It can be for the benefit of the surviving spouse and descendants, okay? But it is not as good in this day and time for income tax purposes. So if a client, let's say a couple, have less than 2 exemption amounts, and that's 95 to 98% of people in this country, probably the use of a bypass trust is not appropriate. But the bypass trust is still a very valuable tool, and couples with amounts exceeding the exemption amounts or far exceeding the exemption amounts should probably have a bypass trust in their planning. So again, this is for control of the first spouse to die. It is a non-grantor trust, okay, for income tax purposes. Now, I apologize, that bottom bullet there should not be there. I apologize, so we need to remove that, Jeff. And anybody watching the program here today, you should just note that that bottom bullet point is extraneous. The bypass trust is not a grantor trust for income tax purposes. It is a non-grantor trust. We apologize about that. All right, a grantor retained annuity trust. So we're moving right through the trusts here. It's a powerful tool to remove assets from the taxable estate. It basically involves a gift of assets to the trust, and if the assets in that trust grow more, they outperform the 75/20 rate, the IRS 75/20 rate, those excess assets are out of the grantor's estate. So this is still a very powerful tool for wealthy clients. It's not going to help us as far as getting assets immediately out of the taxable estate. It's not going to be able to be used like an exemption planning tool, but it is a powerful tool. It's a complex calculation tool. They did not take this away. The Congress did not take this away in 2021, so it still remains. And anything again that gets out of that trust that is in excess of the 75/20 rate, that is a asset that goes to the beneficiaries, and the grantor succeeds in getting that out of their estate. A minor's trust. A minor's trust is for beneficiaries under 21 years of age. It's under Section 2503C of the Code. The trustee has discretion over the income and principal of the trust. The beneficiary has no crummy withdrawal right, which we're going to talk about before the end of the presentation, over the income and principal until age 21. So this is controlled until age 21, basically, and the trust can either continue or terminate after age 21 as specified by the document. But if the beneficiary were to die, God forbid, it would go to their estate. So that's a minor's trust. An education trust is similar. It's a tool for grandparents and others. We see a lot of this where we're going to create an education trust inside of a revocable trust or will, or we're going to create that on its own. We're going to create a very substantial education trust because the grantor has purposes that are multi-generational or philanthropic. Okay, it can be created during life or at death. Now, those financial advisors and CPAs on the webinar this morning, you're going to compare these advantages in your own mind and with your own clients to the 529 planning that you can do, which is very powerful. But this is something that really resonates with clients, and it can help them achieve their purposes. Okay, so the tax treatment is going to depend on the various types. I have a case right now where someone is very intentional, very purposeful, very sincere, and very intent on doing good in the world, and they want to benefit their family and charitable intentions in the future for a long, long time, multi-generational. And in that particular trust, sometimes what the grantor wants to do is not necessarily the best thing for taxes. So the grantor is giving up some of the tax advantages for other reasons. So this is going to be customized based on the client's goals. Special needs trusts. These are essential tools for planning. Now, special needs trusts can be revocable or irrevocable. They're for someone who has a disability. They're defined as disabled by Social Security, or the state review team in Maryland, let's say, has deemed them to be disabled, or they have a chronic illness. And I apologize, we should say disabilities with disabilities or chronic illness. It can be revocable during life. So many times these days we create a special needs trust, or a supplemental needs trust, we would call it. And we're going to talk about the various types. We would create this as revocable during the life of the grantors or grantor, so that they have flexibility. They don't have to file a separate tax return. They don't have to get an EIN number. So it's usually revocable these days during the life of the person, but it does not have to be revocable. So for example, let's say someone was going to fund a special needs trust during their lives. They were going to substantially fund that. Then I would recommend that special needs trust be an irrevocable trust because of asset protection reasons and many different reasons. But no matter what we do during life, it's going to become irrevocable at death. So this trust protects the means-tested benefits of the beneficiary, or the potential means-tested benefits of the beneficiary in the future. It's a lifetime management tool to enhance the quality of life of the person. And there are two types. There is the third-party type and the first-party type. So this is where we want you to not have to remember all of this, but to use this as a tool. So the third-party trust, and we call this a supplemental needs trust. This is the bread and butter of estate planning. This is for the parent, grandparent, sibling, or other person who wants to create a trust for the benefit of the disabled or chronically ill person. And it has lots of flexibility in the design, and there is no payback to the state of Maryland. So this is not a payback trust. It is a flexible tool that can be funded during lifetime with life insurance, funded with cash, or at death, it's funded with life insurance, cash, assets from an estate, or retirement plan assets, IRAs, come into this trust. And of course, the special needs trust and the special needs beneficiary is exempt from the onerous provisions of the Secure Act. The first party trust is a trust that's established in federal law. I won't go into all the details of the federal site for this, but in 42 USC, I won't give you the full site of the US Code, these are laws that came out in 1993 in the OBRA 93 Act of that year. These are tremendous powers that allow the D4A type of trust to be established. To make a long story short, I want you to think in terms of a child is injured in a car accident. Someone is injured at birth. They receive large settlements. Someone receives an inheritance they're not supposed to receive. On and on, the beneficiary is receiving funds that is going to disqualify them from means-tested benefits that they need. We call this a special needs trust. It has to be approved by the Attorney General of Maryland. And then once it's approved, which it almost always is, then the assets can be transferred to this trust and the person is protected again, and their assets are not going to be subject to spend down. So the D4A type, it's a payback trust. It has to be paid back to the state of Maryland. Another example of this trust is where the military veteran, the veteran who is receiving a military pension, can actually assign their military pension to this trust for their loved one. So we have many examples of this that are very happy examples of a special needs trust at the death of the veteran, where the pension is going to go into this trust, and for a long, long time, that beneficiary is going to have the benefit of a lot of income coming into that trust. The D4C type is another first party trust. That is what we call a pooled trust, P-O-O-L-E-D, a pooled trust. So these trusts are regulated. There's oversight from the state of Maryland, and they can't really be designed in a different way than what is accepted, but they do have a very important role. So with the payback trust, there is an annual compliance, but with the third party supplemental needs trust, there is no oversight of that kind and no annual compliance. All right, we've been going now for a little bit less than an hour. I'm just going to keep moving so we can get through the presentation. Thank you for your attention. Please put Jeff to work, make him work hard. That's what he likes to do, and we'll just keep moving. Dynasty trusts. So again, these are terms of art to some degree. This is known as a generation skipping trust or a bloodline trust. It's designed as a lifetime trust, or it can be a trust at death. So a trust can be dynastical during life, can be a trust at death that is dynastical. It protects the shares of the beneficiaries from the claims of creditors. But let's talk about creditors real quick. There are some exemption creditors that a dynasty trust would not protect, a spendthrift trust would not protect. And those creditors, basically in a nutshell, are Uncle Sam. Uncle Sam is a super creditor, and a dynasty trust would not protect the beneficiaries or the grantor from tax liability to Uncle Sam. Although you have to get Uncle Sam quite riled up for him to get into this trust. The other exemption creditors are alimony and child support type public benefit or benefits that are considered to be public policy for children and spouses and so forth. So those are not protected, but other creditor claims are protected. Bankruptcy is protected from. It can freeze assets for estate tax purposes. Someone can gift $1 million into a dynasty trust, and that $1 million grows to $10 million, the excess growth is protected from estate tax. So that is the idea, that a dynasty trust can freeze assets for estate tax purposes. And of course, it can last forever depending on the jurisdiction. Assets are not taxable beyond the grantor's generational level. So they're not estate taxable. So the grantor is taxed, so to speak. Uncle Sam looks at the grantor at this level, but as it goes down the generations, there's no more estate tax. Now, there can be generation skipping tax, and that's a whole different subject, but hopefully we have generation skipping tax exemption that's covering this, and there's no further estate tax and hopefully no generation skipping tax. Now, there can be capital gain in the future, but there's no estate tax down the line, and it can last forever. So Delaware has very good dynasty trust laws. Nevada has great dynasty trust laws. Maryland's dynasty trust law is really even more than theirs. So Maryland says absolutely it can last forever. There's no rule against perpetuities. Domestic asset protection trusts. These are self-settled trusts. And I mentioned that the number of states now is up to 19 where a self-settled trust can be created. So let's talk about what this is. So let's say that I am a wealthy individual and I want to have asset protection as soon as possible myself. I want to create this asset protection for myself. I have let's pretend that I'm a doctor and I have a $5 million brokerage account, or I have a $17 million brokerage account. I want to make sure that I have some asset protection on that money. I can actually establish a self-settled trust. Let's say we could do that in Delaware. I could have a Delaware trust, and I'm basically saying that I'm settling this trust. I'm a beneficiary of this trust, but I'm still able to get asset protection as soon as possible. And I believe that the statute of limitations is 4 years in Delaware, whereas in other states, sometimes like Nevada, there's a 2-year statute, I believe. And in another of the asset protection states, there's only a 1-year statute for waiting after you establish the trust. If no creditor claims arise during that time, then you would not be able to be sued for the assets that are in the trust. Now, there are various case laws out there from California all the way across the country. So I'm going to say that a domestic asset protection trust does not necessarily mean there absolutely would be asset protection for the trust settler. It may afford asset protection, and it's usually designed as a dynasty trust or a generation skipping trust. Now, with all that said, we're just trying to give you an overview of this today. For your wealthier clients, these assets these tools, these trusts are there for them. We need to review them. We need to see if they're appropriate for them. Again, we're talking about a self-settled trust during life. Now, there are hybrids of these domestic asset protection trusts that because of the kinds of case law that sometimes comes out, the hybrid approaches are somewhat more protective. And the special power of appointment trust, where the grantor is not the trustee and really has given up control of the trust, those types of hybrids or alternatives to a pure domestic asset protection trust can give much, much more protection, much more certainty about the protection. And as we talked about earlier, the gifted assets are frozen or can be frozen for estate tax purposes, depending on what is trying to be done. A community property trust is a tool for obtaining community property treatment in non-community property states. So let me explain what I mean by that. So many of you are familiar with joint revocable trusts. Well, joint revocable trusts are where we have spouses that use one trust instead of 2 separate trusts. And those trusts really originated from the community property states. So I believe there's either 14 or 16 community property states, starting with Texas, going all the way around the rim of the United States, California, Washington State, all the way over to Wisconsin. And in community property states, not only are the family laws different, but the income tax laws are different with regard to consideration of spouses. So let's pretend I have community property and I'm in a relationship, and I obtained that obviously from from the time I obtained those assets from the time I lived in a community property state. So if I have those assets and then I die, those assets get a 100% cost basis adjustment, a double step up in basis at the first spouse's death. So community property is very advantageous for income tax planning, which is the name of the game today in estate planning. So if I live in Maryland, which is not a community property state, I could achieve community property treatment of my assets if I establish a trust in Alaska, Tennessee, or South Dakota. So a community property trust is ideal for someone who really wants this 100% step up in basis, and they have very significant assets that we were going to otherwise have to get only a 50% cost basis adjustment, okay, in a non-community property state, or there was just this huge concern about capital gain and wanting to make sure we have this huge step up in basis. So subject to the fact that there is implementation costs and there are upkeep costs, this can be the right tool for the right client. So wanted to make you aware of the community property trust. A qualified domestic trust. Now I'm going back to planning between spouses. So here, a QDOT, as we call it, is simply a trust that says, if I have a non-citizen spouse, and I die first, and I leave assets to my non-citizen spouse, if I want to take advantage of the unlimited marital deduction, which is, quite advantageous. It's Uncle Sam allowing spouses to plan very advantageously between the two spouses, then I have to establish a qualified domestic trust for my surviving spouse. Why? Because the US government does not want the surviving non-citizen spouse to take the assets, go back to their home country, and escape taxation under the IRS. So a qualified domestic trust is a powerful tool. We still have that. It's still very much needed. And if you have clients that have non-citizen spouses, their estate planning should really, probably 90% of the time or more, always include a QDOT. What is a qualified personal residence trust? So we're moving right through here. I hope you're staying with me. A qualified personal residence trust is a tool. It doesn't seem to be as popular as it used to be, but it's a discounting tool. I have a second home, let's say, and let's say it's a vacation home. It's a wonderful place that is an heirloom. I mean, this is a property that is not something the family would ever think about getting rid of, hopefully. Well, I can, and let's pretend that I need to do estate tax planning. Let's say I need to do it above and beyond the exemption amounts. Well, now I can discount the value of the gift. I can give this gift. Now, I said something there that I just caught myself on, and I want to make sure that I'm accurate. If we make a gift of a residence into a residence trust, that is going to constitute a gift. And if we had already used our exemption amounts, that would result in gift tax. So we don't necessarily want to trigger gift tax, but I'm just trying to illustrate that as part of estate tax planning, we can give away a property into a residence trust, and we can do it as a discounted value. It's a split gift, a split interest gift, because you're going to continue to use this residence or live in this residence, but you're also getting it out of your estate at a discounted value. And it can be for a term of years, 5, 10, 15, or 20 years. It allows you to continue to live in the residence, but you must pay rent. Your client must pay rent to make this a legitimate discounting tool. So it's not for everybody, but the qualified personal residence trust is a tool in the toolbox. The Crummy Trust. So many of you are familiar with this, Crummy powers. So in the 1960s, there was a man named Mr. Crummy, and it's always good to laugh or find something to laugh about in estate planning. And so this always makes me smile with clients. So I'm smiling today about Mr. Crummy, who had many, many children and grandchildren. And so the IRS said in tax court, hey, Mr. Crummy, you can't use all of those exemption amounts, those annual exclusion amounts, I should say, that you're trying to use. You're trying to make gifts, and you're trying to use your annual exclusion for like 16 or 17 different people. You can't do that. Well, Mr. Crummy argued that he should be able to do that because, not because his name was Mr. Crummy, but because if he makes those gifts, and those are present interest gifts, if I give those gifts and I make those gifts in such a way that the beneficiaries could actually take those monies, which we don't want them to, but they could, then IRS, you can't tell me that that doesn't qualify for the annual exclusion. So he won, and ever since then we have the crummy powers. So a crummy trust is simply a term of art that says that it's got crummy trust provisions. For example, a life insurance trust would have crummy powers. A gifting trust would have crummy powers. I'm making, I have 3 beneficiaries. So I'm making 3 times $15,000, $45,000. I'm making a $45,000 gift to this trust, and I'm giving those beneficiaries the crummy right of withdrawal. So those beneficiaries have 20, 30 days, whatever we say, to make a withdrawal of their share. Those people are not going to do that if they have any common sense, and that means that the gift has lapsed. In other words, it's still in the trust, and the person did not use their right of withdrawal, and that means that under the crummy rules, the donor of the gift has given them a present right of withdrawal, so therefore it qualifies for the annual exclusion. And beneficiaries have to receive a crummy notice. So this is something that we need to make sure clients are doing, because what do we know is coming? A stronger, more efficient IRS. The IRS is going to be stronger and more efficient in the future if the funding ever occurs to give them the additional funds that they need. And so going back and audits and looking at these crummy notices to make sure that the irrevocable life insurance trust, for example, was treated as a valid trust, that's going to happen in the future. We want to make sure clients are in compliance. The quiet trust is not something that Maryland has. Maryland has one mechanism in the Maryland Trust Act that allows a representative to be appointed for the beneficiary. And when you read that in the Maryland Trust Act, it looks like that representative can substitute for the beneficiary as the person who is receiving the information. And that is true. And it almost looks like Maryland would allow us to have a quiet trust. But the authors and the people that are most knowledgeable about the Maryland Trust Act will tell us that that's not really what that's meant for. And also that even if we did that, we didn't want to give the beneficiary information, so we sent the information to a representative for the beneficiary. The beneficiary could still demand the information from that person and still subject that person to a lawsuit. So Maryland does not allow really for a quiet trust, but our neighbors in Delaware, for example, have a quiet trust where you can establish a trust and the beneficiary is not necessarily entitled to knowledge of the trust or information after a certain point. So this is something that's important to some clients. It exists in other states, but not Maryland. And that's either a good thing or a bad thing that Maryland now, beneficiaries are entitled to information and they're entitled to an accounting, of course, and they are not going to be something, it's not going to be something we can do in Maryland to keep things quiet, but that does exist in other states. A standalone retirement plan trust, and we're almost done with our trust review, is a trust that specifically is designed to receive IRA assets, usually large IRA assets on the death of the plan participant. And the traditional use of these standalone retirement trusts is to encourage the beneficiaries to really respect the nature of the inherited IRA and to keep those assets segregated. Now that we have the Secure Act and we have only 10 years for the emptying of an IRA, the uses of standalone trusts need to be, thought about carefully about whether it's still advantageous. But it is generally considered advantageous to segregate large retirement plan assets from other assets that are going into a spendthrift trust. But you can commingle those assets, but it might be a good idea to, in a perfect world, to use a standalone trust for that. So it provides spendthrift protection, divorce protection, and management for the beneficiary. And it can either be a conduit trust, meaning we know there's no minimum distributions now for healthy individuals who have 10 years. So it can be a conduit trust where Every distribution from the IRA must be distributed, or it can be an accumulation trust where it protects those assets even after the 10 years if the beneficiary did not remove all the assets within the 10 years, which most people obviously would do. So this is still a tool. It's something for your clients that have very large IRAs, which I know many of them do, and we need to look at that for each client as they're driven by their own goals, which we're going to talk about in just a few minutes. All right, so we're going to end here at about 10 minutes. So thank you again for hanging in there through a lot of information about 20 or so types of irrevocable trust. Remember, a very brief overview. Grantor trust versus non-grantor trust, this can be very confusing. Here's the rule of thumb. Anytime a trust is a grantor trust, the grantor pays the income tax. That's all you need to remember. The grantor pays the income tax. A classic example is the revocable trust. Another classic example is that a life insurance trust is almost typically always drafted as a grantor trust. Non-grantor trust, the trust pays its own income tax. So this is a spendthrift trust at death, like a marital trust or a further trust for a child or grandchild. Charitable trusts, okay, those trusts have special income taxation rules. And if you're interested in that, Jeff can send you a few slides that we use in various presentations about the taxation of charitable trusts. Charitable trusts are taxed in layers. And so Jeff has those slides. We don't have time to get into them today, but a charitable trust is considered to be a non-grantor trust. Tax reporting is way beyond the discussion of today's session, but basically a grantor trust, the grantor is going to show the income on their own tax return, okay? And that's either going to be done with a 1041 that's going to carry out distributable net income to the grantor, or other more simple methods. There are various opinions about this, and it's hard to dissect the code, but basically there are 2 or 3 ways of thinking about tax reporting when it comes to grantor trusts. Non-grantor trusts, they're going to, a preferred method, a best practice, is to always file a 1041. Carrying out capital gain to the beneficiary is a modern technique that should be drafted into trusts. And managing trust taxation. Remember, trusts are taxed at the highest rate at only $13,050 of income. So therefore, the good trustee is managing the trust taxation, managing the investment ideas and allocations, and making sure that the trust does not pay income tax unless there's a good reason why the trust income was not distributed out to the beneficiary. All right, in the interest of time, I'm going to keep moving. Remember, we want flexibility, generally speaking. We want to think in terms of, as we look at what are in new trusts versus old trusts. Well, for at least our new trusts, we want trust protectors in there, special fiduciaries that have limited powers, but very strong powers to direct the trustee. These could be powers of removal and replacement, powers to amend, and so forth. Special independent trustees. Special independent trustees can be appointed for decanting or other very powerful tools that in the toolbox. Special fiduciaries, for example, in Delaware and Nevada and Alaska, investment direction advisors, distribution advisors, independent distribution advisors. These are the various roles of fiduciaries in certain domestic asset protection trusts, dynasty trusts, and so forth. The attorney in fact, meaning your agent under a power of attorney, that agent can be given certain powers that have to do with trusts. So powers of attorney, again, are tremendous tools that can be designed in conjunction with a trust. And of course, decanting, Maryland does not have decanting, but our neighbors in Delaware and Virginia, and I believe about 20 to 22 states have decanting statutes. Decanting, if used properly, is a powerful tool to be able to change a trust. Remember, a trust protector can amend a trust, but a trust could be decanted by a special independent trustee by moving the trust to the jurisdiction of another state. And through that jurisdictional change or the use of the laws of another state, a trust can be changed from this form into a brand new form. So it's at the same time a very powerful tool and at the same time a very scary tool. And clients need to be counseled about the fact that in the world today, trusts do have a lot of flexibility if we build in the flexibility. But even if we don't build that in, trusts that are older trusts could be addressed in various ways. And I'm just going to check my next slide. And that's exactly what we're talking about here is the older trust that has no built-in flexibility. So first of all, we would look at a power of attorney. Does the power of attorney authorize the attorney, in fact, to create a new trust or to deal with changes to a trust or powers that relate to a trust? So believe it or not, we would look at a power of attorney. Can the trust be modified by the terms of the trust itself or by something that's a more modern creation called the non-judicial settlement agreement? A non-judicial settlement agreement, in a nutshell, says we can change this otherwise irrevocable trust if all the parties under the law, all the parties that are involved agree. And number two, not only that they agree, but that what is being proposed to be done or what is done is something that a court could have done. So the non-judicial settlement agreement is a tool, decanting is a tool, as we mentioned, and court modification or reformation is a tool. And those are the types of things I want you to think about new trusts, flexibility, older trusts, do we have any flexibility? And if not, can we obtain flexibility somehow by restating the trust, modifying the trust, because it's a trust that's going to last for the long term. But if it doesn't have any flexibility, maybe we should stop and say, can we build that in at this point for the long term? Now, how do we talk to clients about these irrevocable trusts? Well, I would recommend that you always emphasize the basics. Remember, in my opinion, a simple way of talking to clients about irrevocable trust is that an irrevocable trust is a trust with a special purpose. I want to make gifts and I want those gifts to be protected from the claims of creditors. Well, that's a special purpose, maybe for a gifting trust or a dynasty trust during life. I want to protect a spouse, but I want to make that gift during my life, a lifetime Q-tip trust. I have a special needs child. I have a special reason, a special purpose to create an irrevocable trust. So it satisfies a goal or a need for the client. It provides benefits or it provides protection. We have to discuss the tax aspects of the trust. Now, this is getting into the weeds with clients, but I find that if we get into the weeds and there's a legitimate reason, which we're going to continue to talk about, the client will be receptive 9 times out of 10. Flexibility components. If we can show the client that here is this, tremendously complicated thing, perhaps that most people would not be thinking about naturally and normally, but it has all this flexibility. And perhaps the client can still exercise some kind of control with the structure of the plan. And the client knows that you understand this plan, their advisory team, the attorneys, the CPAs, the financial advisors, the life insurance professional, all of the people involved understand this plan and they're going to have the support of the team. And that way the client feels like this is something that's fairly straightforward. It's complex, but I can deal with it. So when we dispense with all of our preconceived ideas, I think many of us have preconceived ideas about what we think clients need. And then sometimes we listen. Maybe it's a day where we're feeling really good and we've got things under control and we're just listening that day more than we normally are. When we really listen to clients, we find out what they want, what they need. And now when we've listened carefully, as I've said here, you can really just kind of grab onto the steering wheel, because once you've listened and now that planning is being driven by a goal or purpose, which is very simple, and I apologize about the simplicity of that, but it's very true. If we are driven by the need and what the client wants, their goals, now all we have to do is drive. So not all clients are driven by the same thing. There are clients that we have and you have that have very highly taxable estates, tremendous estates, but they're not driven by minimizing taxes. So we can't make this preconceived notion that clients all want to minimize taxes. Not all clients want to preserve assets, but many do. And so not all clients want a structure that is driven by asset protection. I had a client in the past year who decided that the asset preservation benefits of a domestic asset protection trust was not really what they wanted. They simply wanted to do their exemption planning for estate tax purposes, and they weren't driven by the asset protection. So we just have to be willing and able and listen and give clients time to think. And that's what we're talking about here on one of our last slides as we start to wrap up. We want to give clients the space and time to think, and our clients need that because some of them know what they want. You know that person, they know what they want. Others don't know what they want, and they need the time and the space to think about it, and they need to be, there are certain triggers in the conversation will help them. The counseling will help them. This gives clients the assurance they need. Okay, we're listening, we're being driven by goals, we've got a problem to solve, it makes sense, and we're building in flexibility. Now they have the assurance they need to make these big decisions. This keeps clients apprised of changing conditions because now it's just not a person who is a lawyer, let's say, saying, well, this is what you should do. Theoretically, this is the right thing to do. We have a team that is keeping the client apprised of changing conditions, maintaining and updating the plan during their lives. It keeps the client in control, it builds trust, and it maintains family relationships for the future. So not only the assets under management that you have, or on my end, the client families that we have, but their extended families will continue to be clients in the future. And it facilitates that the plan will actually work as intended. So I thank you. I'm going to wrap up now. We want to not only educate, but we want to give a path forward. So we want to invite you that any kind of a joint consultation is always welcome. Of course, the client should consent to that, but we suggest that we have a consultation. We have lots of tools here at our Columbia office and other offices. We want to include you if you're an advisor, as long as the client is amenable to that. We want the client to complete an estate planning questionnaire. We want to have all the family information. We want the client to relax and understand that this is consultative. We don't charge for initial meetings with clients. We want clients to bring their existing estate planning documents. We don't charge to review most documents unless they're extremely complex. We don't charge to review documents. We want all members of the advisory team to participate. We want this to be collaborative. And the client should prepare any questions they have or concerns. We encourage clients to come in with a pad of paper and all of their questions or a computer list of questions. And we want clients to understand that they will be given time to think, time to decide, time to become educated, time to determine what their goals are. So I thank you for your time and attention. It was a lot to go through. You did a great job. Jeff, I'm going to turn it back to you. I want to wish everyone a wonderful Friday and weekend ahead and a very prosperous and healthy and safe 2022.
Well, thank you, Steve. Great presentation. This is something that we've been having people ask for a long time, and I'm glad that we were able to provide it today. So well done. So we do have a couple of questions, actually one and a few comments saying, job well done, Steve. So we do have just a few minutes. If you have a question, go ahead and pose it. Now be your time to do that. I know Steve has a meeting coming up soon, so we want to try to stop at 11:30. So the question is a crummy trust a type of grantor trust and such that it could be impacted by the legislation on grantor trusts if eventually passed?
Thank you for that question. The answer is absolutely yes. So a crummy trust, a great example of that is the life insurance trust, which is a crummy trust. It's a grantor trust, and that absolutely could be affected by legislation. Thank you for that.
Great, thank you. So as we wrap up here, if there are any other questions, I'll just say, so I'll try to send out, as I always do, a pretty comprehensive email with some information. I'll send the video out. I'll send out the slides regarding the taxation of charitable trusts that Steve alluded to. I will also have your CE submitted on Monday. So if I don't have your ID number and other information for that, please go ahead and get it to me today, please. Also regarding our webinar series, upcoming events, Wednesday, February 9th, Understanding Estate and Trust Administration with Steve. That's always quite a popular presentation. Tuesday, February 15th at 1:30, which is our wellness series, a very popular series, Purpose and Health, the important link with Dr. Michelle Fritsch and Ellen Platt, who's an aging life care manager, wonderful person. Also Friday, February 18th at 10, the Essentials of Estate Planning and Elder Law, also with Steve. Also, if you need continuing education hours, most all of our webinars do offer continuing education hours, so feel free to join us anytime. Let's see here, see if we have some questions. Yes, I will send the video. I overslept. So I wish I had that problem. I can't sleep. Okay, and we do have one more question. Do assisted living facilities need to be informed if Medicaid Protection Trust was established? That's a good question.
That's a great question. Thank you. I'm assuming you mean a continuing care retirement community. Now, a standalone assisted living facility would not need to know about that because, you know, it's if you pay, you can stay and so forth. There's no lifetime guarantee or quasi guarantee. A CCRC, a continuing care retirement community, it depends. I would say no. If you have made a gift to a Medicaid trust before you present yourself to a CCRC, your client to a CCRC, and the CCRC is making its judgment about your entry to the facility based on the assets that you are presenting, then I say you do not have to disclose the Medicaid trust because you're being qualified for the CCRC based on what you are showing as assets and income. But if you are at a CCRC and you make a transfer of assets to a Medicaid trust, I would say that's going to be in violation, or your client would be in violation of the rules and regulations of the CCRC because that's a divestment of assets. Thank you for that question.
Very good. Okay, thank you. So it doesn't look like we have any other questions. Gentlemen, thanks you for the answer. Okay, very good. Well, thank you for your support of the Advisors Forum and our Elville webinar series. Hope you have a safe and wonderful day and weekend. And for those that are going to get it, enjoy the snow today. So have a great day, everybody. Thank you very much.
Thank you, everyone.